intro from me too, or just from Marty summarizing?
No need.
Okay.
We are live. It is Wednesday, July 8th, 2020, 5:02 p.m. We're a little late today. I apologize profusely and with all my heart and soul for that. I have a great deal of to say today, but I'm not going to say any of it. I am instead going to talk about the weather in Washington, because it is really hot and unpleasant here. And, you know, the Supreme Court is handing down religious freedom cases, and I go out for my midday walk, and I do save all my phone calls that I have to do for my midday walk. And by the time I get home from my midday walk and my phone calls for the day, I am sweating so profusely that I have to take another shower.
TMI.
And
can we have a show of hands of who wants to cut this monologue short?
I just want to say that this is unnecessary. And so to the gods out there who control the weather, more rain, cool it down, and let's make midday great again. I know it's only still early July, and we can there's a lot we can do in early July. I shouldn't be complaining yet, but damn, it's hot in Washington. So we are not allowed to have fun anymore. And in lieu of fun, today we have religious freedom decisions from the Supreme Court. We've got 3 of them this term. We've got a great group of people here to discuss it. We've got Marty Lederman, whom you all know from Georgetown. And we've got Tom Berg from St. Thomas Law School in Minneapolis, St. Paul. And special guest interviewer, we have Anna Salvatore, AKA High School SCOTUS, who's going to help Kate and me do the interview, because Anna, I don't know about Kate, but unlike me, Anna has actually read these decisions today. So Marty, get us started without TMI.
We need 2. Okay, so there's 3. One came down last week, right?
1 last week, 2 today. What has the Supreme Court done in the religious freedom department this term?
All right, so last week's decision, the Espinoza decision from Montana, I'm going to be very brief about this, is another in a series of cases involving government funding of religious institutions. In this case, religious schools, K through 12 schools, primary and secondary schools, through a very elaborate, in Montana's case, a very elaborate tax credit and scholarship program that has like 4 or 5 different steps that aren't particularly important unless Anna thinks they are. But the gist of which is, it once was the day, back when Tom and I were Anna's age, and for a long time after that, it used to be the general consensus was that the Establishment Clause of the First Amendment prohibited governments from giving money to churches in particular, and in some contexts to religious schools. And that was the principal question. Until this year, it was the principal question I taught on this question when I taught religion and law. But now in this case, this seems to be the final nail in the coffin on that idea. It seems to be that the court is no longer troubled by any Establishment Clause limits on government aid to religious schools, at least when the aid is neutral, is not preferring religion to non-religion. There's no discretion involved. And in fact has gone almost 180 degrees the other way. Now the big issue is, if a state chooses to treat religious and non-religious schools differently, to fund, for instance, only secular private schools, but not religious schools, which most of the states in the Union had rules against that for many decades or centuries. The court now thinks that's a free exercise clause violation. So we've gone from the funding being constitutionally prohibited to the funding being constitutionally required in a very short span of time. Although the clouds were on the horizon for decades in this direction, but the flip happened pretty quickly once the justices changed over on the court. So that's the short order, is that there's now a new rule, or at least the court purports to apply a new rule, that states that is presumptively unconstitutional for states to discriminate among organizations or entities on the basis of their religious status or affiliation. Now, hold that thought.
Case number one.
That's case number one, and that counts in terms of funding as well, and it won't survive that. Okay. Case number.
So wait, hold on.
Yeah.
Like literally, like one sentence. Like, is this good or bad for people who want to send their kids to religious schools, private religious schools?
It means they will now be able to get money even in states whose state constitutions previously prohibited the money from going to the religious schools.
Okay.
Okay. So
on the same terms that any other school is getting.
On the same terms. In that case, it's got to be absolutely neutral. The state has to be. This is the court is purporting to apply a form of formal neutrality, that the state should not be able to discriminate. Now, before moving on to the second case, I just want to reserve the one really important question still not completely decided in that, is if the state discriminates against the religious use of the money, not the identity or status of the recipient, but what the money is going to be used for, like religious teaching. The court has not quite said that the free exercise clause requires that the state allow even that. But Chief Justice Roberts sent a very strong signal that there appear to be 5 votes for that too in the next case. Tom, would you agree with that? They haven't quite gone to saying the free exercise clause requires that the money be able to be used for religious uses or religious teaching, but the signal is pretty strong.
The signal is pretty strong, and I would add that the status versus use distinction collapses in many instances. But we could talk about that. Why I think
that's the final shoe to fall, but it hasn't quite fallen yet. It's the final of the 3 shoes for the three-legged stool. Now let's move to today's 2 cases. So in one of them, I'll start with the constitutional one first, because in some ways it's in tension with the one I just described. The ministerial exception case. Now, the phrase ministerial exception is something that the lower courts came up with from 1970 until about 8 years ago, when the Supreme Court first looked at the question. And they called it a ministerial exception. And here's what it is. The court reads the free exercise clause and the establishment clause together to give certain religious organizations, churches and some other group of religious organizations, a right to basically an entire exemption from all anti-discrimination laws with respect to certain categories of employees. Now, they were deemed ministers in that first case, and this is a case about teachers who aren't traditional ministers, and so that was the argument. But a 7-justice majority basically holds that ministerial was just a sort of a placeholder adjective, that it's not limited to ministers, but that churches and other religious organizations are exempt from any scrutiny under anti-discrimination laws for any employees who, now the verbs that Justice Alito uses are important, instruct people on the faith, how, what is devotional faith, who try to inculcate the organization's beliefs, who preach, teach, and counsel, in this case, students. So those functions, the functions not only of being a minister or a leader of an organization, but those who are supposed to preach, counsel, inculcate the faith, and who are held out as authorities with expertise in that, as representatives of the organization. Now they can be fired for any reason at all without any judicial scrutiny, notwithstanding that Congress and the states have laws that prohibit certain grounds of treatment, like on the basis of age or disability or race or sex or sexual orientation or what have you. All of those anti-discrimination laws are wiped away with respect to the teachers of the faith in religious organizations. And it doesn't matter, first of all, it doesn't matter whether the organization has a religious objection to that criteria, right? It could be, they're not, so for instance, these two cases, one was an age discrimination case, the other was a disability discrimination case. Neither school claimed that it had a religious reason for firing people on the basis of age or disability. In fact, they disclaimed that they were doing so. And neither school had a religious reason for what they did here. They weren't claiming that these firings were done for religious reasons, but nevertheless, they just get out of litigation right on day one under this holding. So we can come back to that. I think there are 2 or 3 lingering important questions about the scope of that decision, but I found it not very surprising given where the court was and how the oral argument went. At times, a lot of the briefs were arguing for a much broader holding that would cover even more employees, but it seemed clear to me that there was a majority to cover the teachers who teach devotional faith or who try to inculcate devotional faith, even if they're not part of the church. Okay, the third case is colloquially known as the Little Sisters case, although as many viewers might know, I resist that because I think the Little Sisters was sort of a stalking horse here. The Little Sisters really were not burdened at all by the contraception rule because their employees were actually exempt. They weren't going to get the coverage. This is the third in the series of cases involving the Obama administration's, at the time, so-called contraception coverage rule. So under the Affordable Care Act, that's Obamacare, as you might recall, Hillary Clinton and a bunch of senators decided that it was very important not only to provide comprehensive health insurance for all Americans, but to make sure that insurance covered preventive care in order to hold down costs and provide better health for all Americans, that it was important that insurance would pay for things to prevent you from getting in having healthcare problems in the first place, and in particular that women's preventive care needed to be funded cost-free in every health insurance plan in the country, or almost every health insurance plan in the country. So that involves, for instance, breast cancer screenings, certain baby treatment issues. It involves outside of women inoculations, vaccinations, and the like. But in particular, a federal agency decided that it also meant giving women coverage on 18 different cost-free health insurance coverage for 18 different forms of birth control, most importantly including the IUD, the more effective but more expensive forms of birth control, on the idea that that would prevent unwanted pregnancies. And in fact, pro-life legislators or some pro-life observers thought this, Justice Kavanaugh, when he was a judge, noted that this would decrease the number of abortions nationwide and unwanted pregnancies generally, and give women greater equality in the workplace. But the Obama administration always included a carve-out, an exception for churches. It was never very clear what the statutory authority was for carving out churches, but they did it. Then a bunch of organizations, starting with for-profit companies like Hobby Lobby being the most famous, started objecting that they didn't want to provide their employees with healthcare plans that included contraception or certain forms of contraception, and that they had a right under the Religious Freedom Restoration Act, RFRA, to an exemption from that. And as a way of dealing with that, the Obama administration came up with what's called the accommodation. And accommodation was meant to be a win-win situation. They figured out a way, it's sort of complicated, I don't want to get into it here, where the objecting employers would not have to make contraception part of the actual, they wouldn't have to pay for it or make it part of the plan that they provided to their employees, but the insurance company themselves or third-party administrators would have to provide cost-free coverage to women. So it was which satisfied most objecting employers, but not all. That satisfied most objecting employers, but not all. There were still about 100 employers nationwide, mostly nonprofits, who claimed that even the accommodation, even when their employees were getting coverage from an insurance company or from a third-party administrator, they were still complicit in the use of the contraception, and therefore they needed a complete exemption the way churches did. So I hope this is clear. There were 3 categories: those totally exempt, those who got the accommodation, and those who were required to keep the contraception in their plan. And the issue here was how broad should that first category be of completely exempt employers? And for them, their employees and their female beneficiaries of their employees would just not get contraception coverage at all under this regulation. As many viewers might know, this went up to the Supreme Court twice, once for Hobby Lobby and for-profit, the second time with nonprofits, never completely resolved at the end of the Obama administration. Trump comes in, and the agency in question, the Health Resources, and I'm always forgetting what HRSA stands for, Health Resources and Services Administration, does an about-face and decides that virtually any employer that has either a religious or a non-religious moral objection will be given a complete exemption so that their employees do not get coverage. So that was challenged from the other direction, from the states of Pennsylvania and New Jersey, who claimed that their residents their women in their states would lose out on this federal benefit, that they'd have to cover for that loss of benefits, so they were injured. And they came in and they challenged the Trump administration's desire to basically expand the total exemption to cover nonprofit and for-profit companies just on their say-so that they had either a religious or a moral objection. And in a 5-2 vote today, the court upheld the Trump administration's expansion of that exemption for the most part. It upheld it against several of the challenges. The principal challenge was there's no statutory authority to exempt these groups. So the principal argument was just a statutory argument. HRSA has to say what women need and then require all employers to cover it. There's nothing in the statute that gives HRSA the authority to exempt various organizations. The court said, no, that's wrong. We read Obamacare, the Obamacare statute, to provide a very broad delegation to this health agency, not only to determine what forms of contraception are covered, but which employers have to provide it. And there are 7 votes for that proposition. Justices Ginsburg and Sotomayor dissent. There's one remaining issue in the case, and that is whether the breadth of the exemption that the Trump administration has created is arbitrary and capricious under the Administrative Procedure Act. And the case is going back to the Third Circuit, and Pennsylvania has already announced this morning that they are going to press their arbitrary and capricious argument. And Justice Kagan, in her separate opinion, joined by Justice Breyer, gives, I think, a very compelling reason why the breadth of this exemption probably is arbitrary and capricious. And so maybe that would, carry the day for a while, but we're only, how many days till election, Ben? Ben, how many days till election? You're the counter.
Yes, but I was muted.
Sorry.
It's 119, I believe.
Okay, so 119 days. For the next few months, this will probably mean that 100,000 or so women across the country, it might be 70,000, it might be 300,000, no one knows for sure the total number, will no longer get cost-free contraception from their health insurance plans until this is resolved. Now, if Biden were to win the election, the court's decision today will probably allow Biden to put back in place something like the Obama level exemptions and try to defend those. So this was a fairly narrow holding. It could have been broader. The Alito files a concurrence saying RFRA requires these exemptions. That holding would have prevented the Biden administration from going back and going back to the Obama, where Obama drew the lines, or something similar to it. This is something of a holding pattern. I don't want to minimize the fact that it does mean 100,000 or more women will have to pay for their own contraception for several months, and for many more than that if Trump were to be reelected. But it basically throws it into the administrative process once again, and did not make very much law under RFRA, which was what I urged the court not to do in an amicus brief. And I think a lot of people were sort of relieved that the court didn't go the way Justice Alito would have, which would have cut off the discretion of the agency to shape exemptions. So those are the three cases. I hope that wasn't too quick so that you couldn't understand it, or that our viewers couldn't understand it.
No, it was excellent. Thank you, Marty. Okay.
Yeah, I was going to say, Tom, I wanted to hear your reaction to that. And Anna, I was going to turn it over to you for the first question to the panelists. But Tom, that was an excellent summary, Marty. I think that was actually really kind of, frankly, very kind of not in the weeds, but like high level without being too in the weeds. It just was like a really good kind of walkthrough. And I think that you kind of didn't skip any of the important little sub issues and things like that are still dangling. And so thank you for kind of setting us up so well. Tom,
I did skip some because I want to discuss with Tom sort of the dangling issues, especially the ministerial exception. But just wait till tomorrow, Kate. Wait till tomorrow's description of the subpoena decisions.
Oh, geez. Okay. Well, hopefully we can, I am looking forward to that. It's funny that you said that you start kind of the conversation of teaching religious freedom in your con law classes around kind of this idea of distinguishing, but kind of between like tax exemptions versus kind of withholding money based on religiosity. Like there's like all of these kind of elements that are playing out in various ways in these three decisions. But I'm kind of interested, Tom, what of these three were you most interested to kind of hear about? Maybe all three? And what do you think, Marty says it's a holding pattern. Do you agree with that?
So, remember like 2 weeks ago when the court decided Bostock, the Title VII cases, and there was a great deal of Sturm und Drang on the right about how the court was allowing now open season on religious traditionalists. And I think the last three decisions indicate that this is a court that, whatever position it took in Bostock on the scope of Title VII is very much committed to protecting religious liberty. And I think that's a good thing. In two of the cases, I filed briefs and was happy to see the court rule the way it did. I think they're good decisions, they're sound decisions, and they strike the right, right scope. So I've filed in Espinoza and in the ministerial exception cases, the tax credit case and the ministerial exception cases. We could talk about the individual details, but let me just, at a really 30,000 foot level, and I hope this doesn't get too broad. Well, first of all, let me just say, I think protecting religious liberty across the board is really important in our current circumstances. We are, it's just a cliche by now, but we are obviously a deeply polarized society. And one purpose of protecting religious liberty is to reduce people's fear that their deep commitments are going to be attacked by the other side. And we certainly have a lot of that kind of fear going on now. Religious liberty concerns, actually, there are surveys that show they ranked pretty high on the concerns of people who voted for white evangelicals who voted for Trump in 2016. If we could get to the point where we would respect religious liberty for all groups, I think it obviously wouldn't solve our deep problems, but it would be a step towards it. And so for that reason, I was very much against the Muslim travel ban, thought the court should have struck that down. So I think both the tax credit case and the ministerial exception case are justified as a matter of protecting the choices of individuals about whether to engage in religious activity or not. Individuals and the groups they form. A religious school formed by the people who want to patronize that school ought to be able to make decisions about who is teaching religion in that school. That's a matter of religious choice. And the same thing for the parents who use the religious schools, so the tax credit facilitates that. So there's a little bit of suggestion from Marty that there's a deep inconsistency between saying equal participation in tax credits, but also having some exemptions, sort of special concern for religious freedom. I actually don't think that those two are inconsistent, and we argued that in briefs to the court, Doug Laycock and I. So that's a very big picture view. We could get down into some more of the details, but I'm a little more ambivalent about the Little Sisters case. I think the court is basically right there, but I would not probably would not find a RFRA violation against the Little Sisters. On that, I probably agree with Marty.
When
Hey,
you
Tom,
say
would-
the court,
Tom, would you
When you-
agree that this is?
Can I just ask you? Sorry, go ahead, Marty.
No, I was going to ask Tom. I just want to find places of broad agreement between the two of us, and I think there are some. Which is, I think it's fair to characterize this court, the majority of this court, but also to a certain extent, Justices Breyer and Kagan, as probably the most free exercise friendly court in our lifetime, even without overruling Smith. Free exercise and RFRA friendly, that is to say, religious exemption friendly, and the most, with the weakest commitment to establishment clause values in our lifetime. So, which is not a surprise. All five of these justices had sent signals to that effect through much of their careers, and it's not a surprise. But I think it's quite a remarkable change over the course of our lifetimes in what has happened.
Well, I'm with you part of the way. Anna, do you want to? I can answer that, but I don't want to monopolize here.
No, please go ahead.
Yeah, go ahead.
So, yes, this is a very free exercise oriented court, and Kagan and Breyer join in that, at least to some extent. This is one of the least separationist courts we've had in a long time, in the sense that they don't believe in the kind of view of separation of church and state or religious liberty that means you can never give any kind of aid that benefits religion. So I'd amend, Marty, a little bit. I think there can be a commitment to establishment clause values without striking down these aid programs that help families, choose their school. And in fact, the establishment clause probably supports the ministerial exception decision because, getting courts involved in who's a minister in a religious institution or a religious school invites the courts to make judgments that are inconsistent with establishment values. The place where the court is very clearly more pro-establishment is that seems to be moving in the direction of allowing more actual speech by the government itself on religious matters, like the cross in Maryland last term and a couple of others. I think we'll see more of that. And that I would agree with you, Marty, is weaker on the establishment clause. But the other ones, I think it depends on how you read the establishment clause. Is it a guarantee of pluralism or is it a guarantee of no aid to religion? Those are not always the same thing.
Anna, do you have any questions?
Yeah, sure. Professor Berg, you've written at length about the ministerial exception in blog posts and about the case that was decided this morning, Guadalupe. Could you talk a little bit about the history of the ministerial exception in the United States and why both you and the Supreme Court was worried about having a really narrow version of the exception?
Yeah, thanks. Great question. So the ministerial exception is, I think Marty has sort of described it. It's a rule that applies to at least two anti-discrimination claims by ministers, and says that if this case would involve a claim by a minister that would somehow involve the selection or hiring or firing or discipline of a person who's a minister, then the suit can't proceed, period, no matter what the basis for the alleged discrimination, as Marty says. That exception was first announced a few years ago, 2012, in a case called Anna Salvatore. But it was there in the lower courts for about 40 years before that. Every circuit had adopted something like that rule, every court of appeals. And it was all, those opinions were grounded, the Court of Appeals rulings were grounded in earlier, more general Supreme Court opinions about the autonomy of religious institutions to choose their leaders. So this goes back and it goes back really to the beginning, to colonial times and to the founding. It was very much a part of established churches that the government would decide who was qualified to be a church leader. And now we don't have an established church, but some of the same worries about civil authorities, in this case, judges hearing a discrimination claim, same worries about those authorities making a decision about who should be a minister and whether it was justified to remove this person. The court says that they still apply. In this case, what you had was a school teacher in a Catholic school, in each case, somebody who, they were teaching fifth grade students the whole range of classes, but they were also teaching a Catholic religion class, and they were really teaching Catholic doctrine. So they were doing religious teaching, and because of that, the court puts them in the definition of minister. They didn't have the title of minister. They were called teachers, as you might expect, and they didn't have any kind of formal training as a clergy member or anything like that. The court said that doesn't matter. What really matters is, are they doing vital religious functions? And court explains at length, that they were doing a lot of important religious things, and in a religious school, the teacher is very important. It's the way in which doctrine is communicated to the students in a Catholic school is through that classroom teacher. That's, I guess that's how I'd answer that. I hope that kind of gives an overview.
A quick follow-up. So a big tenet of the opinion this morning was that the court doesn't want to intervene and interfere too much in religious schools' practice of hiring and firing people. How will courts determine whether an employee has significant religious duties, though? Will that become an entanglement problem of its own?
It has some potential to do that. I mean, anytime you're drawing a line, there are judgments to be made. Justice Thomas, who concurred in the opinion, would have taken that to lead to the conclusion that once the school says this person is a minister, that should be the end of it. No, just don't second guess at all. No questioning of that. The majority did not say that. They said you give, I don't remember what the language is exactly. It's something like substantial deference. Judges should not be just substituting their own judgment about how important this is. They should be respectful and deferential to the school's views. But it's not going to be an absolute thing. I think a couple of things that shouldn't matter. For example, if it's important that they're, sort of preparing students for mass or teaching religion, that can be really important, even though it doesn't occupy, 50% of the day. So what the court has called the stopwatch rule, that, if you're only doing this 10% of the time or 15% of the time, well, that must not be a very important. That's a wrong kind of criterion, and the court set that aside today as a way of deciding.
Tom, if I could, let me tick off some things that I think were decided there and what weren't, and I'm curious what Anna and others think of which are important of these questions going forward and whether you agree. So what was decided, I think, is that even it doesn't matter whether the teacher is even a member of the church. So a Jewish or atheist or Muslim teacher in a Catholic school, if that person is assigned to teach Catholic faith, at least inculcate Catholic faith, they don't get any of the rights. Now, the court didn't quite go all the way there, but that seems to be the implication. And also, of course, as in this case, it doesn't matter whether the school fires you for a religious reason at all. You're just immune. So I think those two things are pretty well established. The four things that seem to me to be the next issues are, number one, what about teachers who aren't teaching devotional religion, they're teaching biology and math and the like, and they're told that their way they teach those has to be consistent with religious faith, with Catholic faith, but they're not supposed to be inculcating the tenets of Catholicism or some other religion during that. I doubt the court's going to go that far as to cover those folks. That's number one. Number two, what about employees that the church doesn't intend that they teach students or others, but that they model the faith, right? That their behavior outside and inside the employment place is supposed to be consistent with the faith. That was at first what many of the briefs were pressing the court to go. But by the time of oral argument, the Beckett Fund had ratcheted way back and said that no, modeling is not enough to cover it. And I'm not sure there are 5 votes for that, let alone 7. So I think just asking employees to model the faith and to be would not trigger the ministerial exception. Third, what about laws other than anti-discrimination laws, contract, tort, and the like, other reasons for being fired, other employment laws, wage and hour, other laws? That's a totally open question, and we don't know how the court's going to deal with that. And finally, this wasn't mentioned in any of the opinions, but what about notice? Like, so Jeff Fisher, who represented the employees here, his point was when they were hired, the church didn't tell them, oh, by the way, you don't get any of your statutory anti-discrimination laws. They were blindsided. They were like told when the litigation started, oh, by the way, you don't have any of the rights that you want. Does the law require the schools or churches to tell the employee on day one or when they're applying or interviewing for the job, oh, by the way, this job, you lose all your statutory rights if you take this job? Something that they would be reluctant to say, I think. It would make it harder to hire teachers, for instance. The court does not hint in any way that there's a requirement of ex ante notice, but I do think it's an issue that might come up in the future. So I'm just curious whether Anna and Tom think any of those 4 things are important.
Can I just 2-finger Marty's last question, which is like about notice, which is like, when do we provide that level of notice to any type of employee or person when they enter any jurisdiction that is not going to be consistent with the laws of the jurisdiction they're leaving from? So like, for example, abortion, like, that like you might have certain types of laws that are on the books in Texas that are not, or Kansas that are not on the books in neighboring states. And it's not like there's like a posting that you cross the state line and it's like, hey, by the way, you better not be 8 weeks pregnant and looking for an abortion in this state, or whatever. And so I just kind of, that's just a much broader question generally. But I think your question is a tremendous one. And I think it's for a bunch of reasons. The problem is
there's no place for them to look. It's now pretty clear if you're going to be a teacher in a religious school, you should assume you don't have anti-discrimination rights after today, just by virtue of the Supreme Court's decision. It's not in a statute somewhere. But beyond that, you don't know when you're hired into some other position whether you're going to lose all your rights. And I'm not sure the churches will tell you are.
Okay, let's give Tom a chance to answer these questions.
I mean, I don't know if does federal law require a employer who is not covered to say to employees that they're not covered? Do all employers of under 15 employees have to put up a notice saying we are not covered by Title VII? I'm not aware that they do, and so I don't see where the ground in the statute for requiring it would be. Marty, your question may be, suppose Congress changes the law to say that, or a state puts that in its law, and then the employer says that would be, a kind of scarlet letter on us, which I imagine that some would probably argue. Does the ministerial exception protect them? I think employers do have to give notice, at least some reasonable notice of their religious character and the kinds of rules that they have. That seems to me entirely fair, and that was certainly true in both of the teacher cases. It was clear to the teachers that they were fulfilling religious functions. The handbook made that clear, but I'm not sure about extending that, to say, I'm not sure what the legal basis would be for requiring a school to announce that their employees are not protected unless the statutes were amended.
So I want to kind of, partly as a thought experiment and partly because I think I actually believe that, I want to outflank Justice Alito here for a minute. I find it stunning that even a serious question that a teacher in a religious school might be subject to, that there might not be a free exercise right on the part of the school to follow require dogma with respect to that teacher, irrespective of anti-discrimination laws. And I think I want to be provocative in how I say this, but I think we actually, by focusing on Christianity, which is a highly doctrinal religion, we actually obscure how obvious this point is. So if you think about it from the context of traditional Judaism, where there is a ethnic dimension as a matter of religious conviction to the definition of who's within the club and who's not, right? So, Judaism in traditional Judaism is passed matrilineally, and therefore has a kind of an ethnic dimension to it that is not present in Christianity. Believe I'm not an expert on Hinduism by any stretch of the imagination, but I believe there is a similar quality in Hinduism. You can't really convert to it. It's something you're either born into or not. And certainly if you go out in the further reaches, there are religions, for example, the Nation of Islam, not Sunni Islam, but the Nation of Islam, the Black Muslim organization in the United States, has an explicitly racial dimension of its religiosity. And it seems to me bizarre to suggest, and I'm frankly shocked that Justices Sotomayor and Ginsburg would take this position, that a teacher who has obligations in the faith of the Nation of Islam under Louis Farrakhan is bound by anti-discrimination law. And so I guess my question is, what am I missing here? Is it really the position of two of the justices that a ultra-Orthodox Jewish school needs to observe gender discrimination law in hiring teachers that are going to teach, among other things, traditional Judaism?
Well, one thing you're missing, Ben, I think, is that the ministerial exception isn't limited to those cases. Like these
to
cases.
What cases?
To cases in which the person is fired or not hired because of a religious objection to something, like the classic case being the Catholic Church not ordaining female priests. These are cases in which they're not claiming a religious obligation to not hire the elderly or the disabled. In fact, they're not claiming a religious reason at all for these firings. They are just exempt hook, line, and sinker from these laws, no matter what their reasons are. So even if you're sympathetic to the cases where there's an actual religious tenet that is in direct conflict with an anti-discrimination law, and that was the case in Hosanna Tabor. The Lutheran church there said we have a religious rule, which is you can't take disputes outside the church. The Americans with Disabilities Act gives you the right to take disabilities claims to the EEOC. There was a conflict. Even if you think the church ought to get an exemption in that case, the ministerial exemption just goes well beyond it. And I think that's what's bothering Justices Sotomayor and Ginsburg.
So wait, can I just clarify that? Are you saying that if the Nation of Islam, which is an organization, I mean, I'm kind of making up their doctrine here, but forgive me, they're an organization of Black Muslims that are explicitly racial in their kind of worldview. If they say, hey, we don't want to hire white teachers to instruct people in the doctrines of the Nation of Islam, Justices Sotomayor and Ginsburg would be okay with that. and would agree that there's a free exercise problem there. It's only when they say, hey, we want an exemption even from the age discrimination and pregnancy discrimination laws about which the religion has perhaps nothing to say, that you run into this problem.
I don't know what Justices Ginsburg and Sotomayor would say about that case.
I mean, Ben, your question raises a really interesting point about the kind of interplay between different kinds of protections. I think the ministerial exception has had more weight put on it, probably because some of the other possibilities for that narrower protection that you're talking about, where there's a religious tenet that would be contravened by the anti-discrimination law, those other vehicles haven't been available. Like under the free exercise clause, you can't generally get an exemption from a generally applicable law. The ministerial exception is the only one. So everything flows into the ministerial exception. And there's an exception in Title VII for religious organizations, but it maybe only covers religious discrimination and things like that, and doesn't cover racial discrimination. So next term, and Marty, you'll respond to this. Next term, the court is considering whether to put some more teeth in the free exercise clause generally. And I wonder if it does that, will that reduce some of the pressure on the ministerial exception to expand? So just a thought.
Interesting.
I'm really curious to the extent you're comfortable saying so. I'm curious what Anna thinks of all this, because we've been in the weeds on this for decades, and it's always good to get a sort of a fresh take from the younger generation on these.
Sure. Well, I actually had
You
the same...
represent your generation, Anna.
No pressure. No pressure.
Well, I kind of had the same question you did, like what happens to the biology and the English teachers at the religious school? And it reminded me of the string of cases like Garcetti and Bramerson, where the Supreme Court is warning against making job descriptions like way too broad for employees. Like, in other words, the justices don't want you to be considered always on duty and thus constantly accountable and fireable for all speech, like fireable for a prayer before you're coaching the football team or some inappropriate remark you make in the teacher's lounge. And I do kind of worry that there's a similar danger here if employees have overly broad job descriptions, like, as you pointed out, Professor Lederman, modeling the faith, even if you're doing something that doesn't seem like it's related necessarily to religious instruction. So I'm not sure which rights the school would be violating of the teachers if it did have an overly broad job description, but that's something I was concerned about as well.
Can we switch to Three Sisters for a little bit? I know this is like a totally different thing than the ministerial exception, but one of the things that you said, Tom, was that you thought that this wasn't surprising following Hobby Lobby, you said that this wasn't hugely surprising. And I'm curious whether you meant that as it wasn't surprising they followed basically the precedent set out in Hobby Lobby and extended it, or whether you thought it was because you just thought the reasoning matched everything else, or maybe both. I mean, maybe those are not separate things.
So I don't remember exactly what I said. As Marty said, the kind of the religious freedom question about whether this violates RFRA, the court technically ducked that question about whether it would violate RFRA to make the Little Sisters or some other religious organization, provide a form saying that it objects, which would therefore activate its insurer's duty to, or a third-party administrator's duty to provide contraception. The court ducks that technically, although it does say that there was a significant RFRA issue there, and that the Trump administration could rely on the possibility of a RFRA violation in order to act. under the ACA. So, I think it's a question, it's a case largely about the discretion of an administrative agency to make religious accommodations, whether that's under the ACA or also under how much scope it has to take this religious freedom statute called RFRA. And even if it might not be absolutely clear that this would violate RFRA, they can still carve out an exemption that would respond to the RFRA concerns. That's why Marty is right that it could go the other way if the Biden administration comes in and presumably will reverse the rule, like maybe on day one. It'll be on like the list of day one things that a new president does, which is going to be extremely long in this case, I imagine.
Two quick points on Little Sisters. One is that, contrary to what Tom just said, actually the Little Sisters themselves, even if they had opted out, their employees would not get the coverage from the third-party administrator, which is why they should never have been.
Yeah, I meant. Yeah, I meant other.
But also, I just wanted to tease Kate because Kate, you called it Three Sisters, and I assume that's because you've got Hamilton on the brain, right?
Yeah.
And the Schuyler sisters case.
I think that is what I was. It was also a reference to the Three Sisters as a term in farming that is about like planting corn and squash and beans all together in the same little like.
And we could go on Macbeth. We could go on Macbeth.
Sorry.
and
the witches.
Sisters. Yeah,
the weird
sisters, hand
sisters,
in hand. Yeah, so we can go any direction on that.
But it's a case about discretion, and it gives a fair amount of discretion to the agency to accommodate religion. I think the signal is that it wouldn't. Marty is right that there's a remaining issue that'll go back to the lower courts about whether this regulation was capricious under administrative law. I think the signal from 5 justices is that they would not find it arbitrary and capricious. Kagan disagrees. She signaled that she would find it, but there's only, I think, 4 justices.
And I think
would you agree, Marty, that the signal from 5 is that it would?
I think the signal from 5 is that, as to many of the employers, they won't find it arbitrary and capricious. But the very breadth of this, the moral exception and the for-profit, maybe that stuff would be thought of. But I also think this is going to be, by the time the lower courts start dealing with this, we're going to be into 2021, which is going to reset the table in some sense.
All right, we've got 5 minutes. We've got 2 questions from the audience that we should get to. I'm not sure if your name is Alden Daniel or Daniel Alden, but please unmute yourself.
We asked him this already. It's Alden Daniel. Yeah.
It's Alden Daniel.
Yeah.
Alden Daniel, unmute yourself and the floor is yours.
Great, thanks. So I guess my question is whether the ministerial exception or any other parts of the cases today apply to specifically hiring or firing the teachers, and like whether or not it could be applied to anything else about labor laws, for instance, hiring children as ministers or any other position within the church.
Tom, you want to take that, Marty?
I just say those questions are left open, and Chief Justice Roberts, in the earlier case that Tom mentioned, Hosanna Tabor, was very careful to say, we're leaving a bunch of hard questions for the next case: contract, tort, other employment laws. We're just dealing with anti-discrimination laws for starters here. So that this is just a huge open question.
All right, I think I know that Ruth comes before Greenblatt, but the floor is yours, Ruth.
Hello, I'm a physician, actually, an infectious disease physician, recently retired. But my question is, so a Jehovah's Witness employer can eliminate blood product coverage from his employees' insurance. And I guess this is really part of a broader question. You have lots of various sects in this country who have specific preferences about coverage. And so would a Scientologist employer be able to block various psychiatric drugs from his employees? And if they can, if you think about it, this will really increase the cost of operating insurance programs, because you'll have a multitude of little clauses. And some of the things like blood products can be extremely expensive. It's not like contraceptive pills where the person might face a limited cost. So I just like to hear what people think about that.
So because the court didn't reach the RFRA question, so far all those other religious objections to blood transfusions and the like are not possible, because the Trump administration has only given an exemption for contraception coverage and not for any other coverage. Now, maybe some other administration would try to do that, although I'd be very doubtful that they, get rid of blood transfusions and the like. So the real question there, Doctor, is I think whether the court will read RFRA very broadly to require religious exemptions that wouldn't be limited to contraception, but would go to all other forms of insurance coverage as well.
Tom, do you agree with that?
Yeah, I think that's right. And the Hobby Lobby decision doesn't suggest that it would extend to other kinds of denials like that, because what the court ultimately said in Hobby Lobby, for all of the anger about the Hobby Lobby decision that is out there, all the court said was that there was this alternative method of having the insurer pay for it, and that alternative method would work because contraception actually saves costs. And therefore the insurer is not going to have an extra burden on them. That's not going to be the case in many other situations, so that mechanism wouldn't work. So I think Hobby Lobby is, some people, read Hobby Lobby as an extremely broad decision, and I don't think it's quite as broad.
Anna, do you have any final questions?
I have a question for Anna.
Sure.
What high school teaches all of this detailed Supreme Court?
You don't think she learned this in a high school?
What the hell? Of course she taught this to herself.
I learned this despite high school.
Just like Ben did. If you keep inviting people on, Ben, that are self-taught lawyers, we're going to be out of work pretty soon.
Yeah, that's the idea. But get rid of the bar exam.
Somebody asked me the other day on the show when Anna was here, how did you learn so much law? And I'm like, you never went to law school. And, I was like, Anna's never been to college.
Yeah. I had a response to that I was thinking about. You don't need to start with difficult case law or law review articles. You start with what you're interested in, and then you build from that. If you read an opinion on First Amendment, like Tinker, and you just start with that and you look up the terms you don't know. If you're interested in gay rights, read a Bergefell and do the same thing. And then it becomes less intimidating to you and you keep on reading. That
is such good advice. For those of you who don't know, Tinker, of course, is the canonical case about the free speech rights of public high school students, which is why Anna might have been interested in it. So she can't get punished by her high school for.
Wait, is bong hits for Jesus Tinker?
No, Tinker is
post Tinker.
Okay.
Yeah, but there are so many interesting Supreme Court cases that are just about teenagers and that are relevant, like Hazelwood about censorship of school newspapers. So it's not hard to find something that really hits a teenager and has immediate relevance to their life and for anyone, an adult. So
that is such great advice. Follow your muse. Get into something based on what interests you, and it will open up whole worlds to you.
And don't let it intimidate you. Yeah.
Yeah, that's great. And the first thing I do when I get off this call is going to be to follow high school SCOTUS.
Thank you.
So,
what are you going to call it next year?
Great.
That's the question, isn't it?
Are you going to call it freshman SCOTUS or something?
But then it would go out of date when I become a sophomore.
I think she needs to own it as her own brand. It needs to be Anna's SCOTUS. It's just like she just owns all of SCOTUS. It's no longer.
Stick with it as high school SCOTUS because you started it when you were in high school.
That's an option.
You can be like 60 and still be high school SCOTUS because once upon a time you were in high school.
I would be fortunate to do that, but like Jost on Justice, Salvatore on SCOTUS. I'm thinking of all the options I'm exploring, or just writing for the school paper in college. I might.
But if and when you ever get to Princeton, if they ever reopen, don't punch the bursar. Is that too inside baseball? Everyone
No,
should.
no, I know.
No, everyone
Okay.
got it, Marty.
Everybody
We were all
knows it.
rolling
Now
our
I'm-
eyes.
Pardon me. Are you Aaron?
But I want to just quick correction. I was wrong. Tinker is not fuck the draft. Tinker is black armband
Yeah.
in a high school.
But it's
My-
about the
my-
draft. It's about the draft. About the war.
It's about the draft, but it's not the fuck the draft shirt case.
Like it's basically
Um,
saying that, but yeah, different.
Yeah, but I'm giving out information. It should be accurate.
Yep.
We've got to wrap up. We are going to get Mazars and the subpoena cases tomorrow,
and
and we're going to get McGirt. But we're gonna treat so McGirt, for those of you who don't know, is the question of whether half the state of Oklahoma is actually the sovereign territory of the 5 tribes. I am obsessed with this case. And we are not going to deal with it tomorrow, except maybe in passing, because we're going to be focused on the subpoena cases tomorrow. But next week sometime we're going to get some tribal lawyers. We're going to get. I'll see if Lisa Black can come on to. We will do a full hour on McGirt. But tomorrow it is Mazars and the New York grand jury. It's going to be wild and woolly. Marty, will you be back?
I'll be back. I want to make a prediction, see if Anna agrees with me. Tom, you can. And so I think 10:01, the court decides McGirt 5-4, one direction or the other.
And they all read their opinions from the bench. So it takes a really long time.
With either Sotomayor in the majority, or if Gorsuch goes with the liberals, he'll write the decision. Then at 10:11, Breyer for at least 6 or 7 justices in favor of the subpoenas in the Vance case. And at 10:21, the chief writing in the congressional subpoena case. And I don't even know what to predict on that one, other than that the chief is writing it, and that it's possible he'll say some of the subpoenas were constitutional and others weren't. But what do you think?
What do you think, guys?
I think you guys, Anna should not go to college and instead go into business with Marty to open up some type of betting regime on SCOTUS.
Not a good idea.
The way people bet on elections.
My track record is horrible. So Anna should.
Well, that's all the more reason that Anna should short you and just do the opposite. It seems like a great business opportunity for Anna.
Do you have a Mazars prediction, Tom?
No, I don't. I would hope that that the subpoena is enforceable, but I don't. I'll leave it to you all.
What about you, Anna?
I'm a First Amendment guy.
What's your betting on Mazars?
Don't have an informed opinion on that.
Kate?
Same as Anna.
I just
whatever the opposite of Marty says. How's that sound?
Okay, here is my prediction. I'm not going to give times of the opinions because that's that
I actually am confident about. That I'm confident about.
All right, here's what's going to happen in Mazars. It is going to be. I agree with Marty. It will be almost unanimous or near unanimous on the New York case. Or at least it will be a very solid majority. I think the chief will not help the president on the congressional side. I agree that there may be some of the subpoenas that are suppressed, but the core proposition that Congress, subject to this statute, gets to ask for the president's tax returns. I think the Supreme Court, at the end of the day, notwithstanding the oral argument, is going to have a very hard time denying Congress access to that information in the face of a clear statute.
So Ben, 2 quick comments on that. I mean, it's interesting you say that because in both the Nixon tapes case and Clinton versus Jones, I think most people thought the president would either win both those cases or they'd be very closely decided. And in both, it was unanimous against the president. And this won't be unanimous, but you might. This
will not be unanimous. But at the end of the day, there is a statute that specifically imagined this situation. And it said, when you need this. The committee here's a process by which the committee can do it.
Well, it's not a
And-
statute, but it's a House rule. But okay.
No. There's
No.
a statute on production to Congress of these of tax returns.
No. So that's the second thing I wanted to say. These cases are only at best peripherally about tax returns. This is about his financial records more broadly and his banking records. And
Oh, right, because this is Mazars, which is the subpoenas to the accounting firm.
Correct. And Deutsche Bank.
Yeah.
Deutsche Bank and Capital One are his banks. And the important thing is not so much his tax records or his tax forms, but whether the House Intelligence Committee will be able to get information about any possible foreign entanglements that he has financially. That's the key question. Everyone's been fixated on tax returns, which I think is sort of a red herring. I think the important thing is whether the Congress and the American people will learn about whether Donald Trump has financial arrangements with Russia and other countries.
Yeah, my apologies. I got the Financial Services Committee.
That one's still
case
back in
confused.
that's back in the lower courts. Yeah.
Right. Anyway, I stand by my prediction anyway. I think at the end of the day, it is a very hard opinion to write that Congress does not have the authority to issue a subpoena to Mazars because the executive branch gets to say, you know what, we question whether you have a legit legislative purpose. And the subpoena is not contested by the accounting firm or the bank. And I just think at the end of the day, you sit down and try to write that opinion, it's going to be pretty hard. And so I listened to the oral arguments. I've heard it, I know why people think that it went badly for Doug Leder and for Nancy Pelosi. At the end of the day, I don't see how that opinion writes. So that's my prediction.
That's the brief that I wrote, but I'm less confident than you are that it'll carry the day, but I hope you're right.
But at least you got you had the issue in the case in your head, which I was talking about a different case. So silly me. We will be back tomorrow, 22 hours and 49 minutes from now. And until then, Kate.
We don't have fun anymore. So in lieu of fun, we also, and in lieu of college, and because of our love of McGirt, we talk about the Three Sisters, which is the indigenous peoples of America's tradition of planting corn alongside beans and squash all together in the same mound because the beans climb up the corn and the squash covers the ground and keeps it moist and free of weeds, and the beans nitrogenate the soil. And there you go. That's what and then the Supreme Court didn't make a Supreme Court decision about that. I just made it up in my head.
Who knew?
All right. So, that is the weirdest exit we've done yet, Kate, but I kind of love it.
I got to keep it real. Bye, guys.
Ciao.
Thanks, Tom.
Everybody.
Thank you.